Thank you very much for the invitation. It's a real pleasure to be here and to continue as we started like 1.5 years ago, at least, academics in Florence, and this is coming now in the form of a book, The Rule of Law in the European Union, with Dimitri and Kim and myself are contributing. So the book will be out very soon, we expect in next month, and we'll invite you to have a look on the contents, because I think it will summarize very much many of the debates we are having today, at least from the European Union point of view. So I'm going to say very little of substance after what the presentation by King, and I will introduce at least 3 caveats to what I'm going to say. The first, that I'm not a lawyer and political scientist, even though I used to mingle around with lawyers, and that have created a kind of confused nature myself, because I don't know exactly what I am here, right? The second thing, the second caveat I want to introduce is that I'm very much of a comparatist in approaching this topic. And by comparatist I mean that scrutiny and compliance with principles such as democracy, rule of law, and fundamental rights is not unique or exclusive to the European context. If you look around the world, there are quite a few regional organizations that have similar kind of ambitions, and quite a few countries that have experienced difficulties and have been put under the lenses of scrutiny. One very clear case that I've come across very recently I'm working on is Venezuela, and it's very shocking how Venezuela resembles very much some of the evolutions and events in Hungary. There are a lot of similarities there. And the third caveat I want to introduce on a more personal note is that I am a former member of the Venice Commission, and this will, of course, influence some of my views, because I have a more positive view to the Venice Commission than is habitual to hear in these debates, and is perhaps going to be seen in some of the things I'm going to say later on. Now, what I want to do in this presentation is first to raise a strong normative case for a larger European Union involvement. Second, I want to perhaps to suggest an additional mechanism, yet another additional mechanism, and you will be a little bit surprised why another additional mechanism, and we'll try to justify that. And then I will try to conclude, pointing in the direction to have some additional element in the debate that perhaps have not been so present so far. Now, the normative case, why the European Union should increase or develop a stronger role in scrutinizing member states' compliance with the rule of law. And I think the basic response to that is the construction of the European Union as a community of law. And a community of law depends very much on the notion of mutual recognition. The states and citizens recognize each other's legal system, but also institutions. And this mutual recognition depends very much on mutual trust, which is at the end the effective working system of this community law. Now, it is clear that with this understanding of community law, mutual recognition, and mutual trust, there are 2 effects that emerge very clearly when a state breaks or risks to break the law. One, there is an externalization effect very clear, in which the erosion of the rule of law can travel beyond borders. And this is not a hypothetical construction. We could argue that illiberal state, a state that does not respect the rule of law, is present in certain institutions of the European Union that take decisions, for example, through the Council of Ministers. But it's also true that given certain elements of the construction of the community law, for instance, freedom of movement, decisions taken by the illiberal state affect citizens that do not belong to the state, to that state. So this is a kind of externalization element in the decisions that a illiberal member state may take. And that creates what is called in literature about the definition of the unaffected principle, which means that in a community of law, all those who are affected by the laws are considered part of the body that should take decisions about that. So in a way, breaking or breaching rule of law affects all of us in the European Union. This is the kind of normative argument I wanted to put forward. Second normative argument is that there is a requirement of consistency between accession conditionality and what we could call membership conditionality. It has been reflected, in my opinion, wrongly with the notion of a democratic dilemma. In reality, it's a democratic paradox. But what is happening now in the European Union is we have a very strong group behavior in which existing members project towards those who want to become part of the club certain conditions, but they are not prepared to respect those conditions. I'm not speaking specifically and only exclusively about the case of Hungary. I can think of a number of cases in other European countries in which this situation has existed. Take the case that has already been mentioned this morning of Berlusconi and the laws on the media that allow unprecedented concentration of means under the Prime Minister's hands. But I could think of more recent events. Take the case of my own country. In 2014, the Spanish government has approved a law on public demonstrations that imposes fines on those people taking part in demonstrations and taking pictures of the police. And those fines can even take to a prison sentence. And I wonder whether this is really within a kind of sensitive understanding of what the rule of law. So this is not only the case of Hungary. We shouldn't really consider this a total exception, although it's a radical case, of course. But there are other cases in which there are issues there to be taken into account. And this is one of the things I want to retain when I'm going to make proposals, is that instruments should not be tailored to address specific cases. I think one principle of constitutional law should be that they are relatively blind to the effects, the immediate effects that those provisions may create in the near future. Constitutional provisions are fair and just because they are relatively indeterminate in the way they will affect different people, different individuals. I don't want to make it myself clear, but it's an essential notion of fairness and justice. You cannot really calculate the effects of the rules on given specific individuals. And because of that, I would propose that we need to design systems which are not specifically tailored to specific situations, yet they work in a specific situation. Right. That would be the principle. Now, what I want to make in this presentation is a plea for a holistic approach. Differently to many other authors that have argued in favor of specific procedures, I think, and that's my line, that we need all of them. We need this dense web of instruments because all of them play a part in trying to prevent breaches of the rule of law. And the second assumption I want to join to this is that enlarging the number of actors with ability to act and reducing the veto power assigned to specific actors may improve the efficiency of the instruments. So the question here is how we increase the number of actors and how we decrease those who can veto an action. And that lead me to propose that we should take into account all the system mechanisms. Article 7 has been called the atomic bomb because of the difficulties to activate, which I don't think is really the case. I think I will propose at the end how to perhaps give more teeth to Article 7. The systemic infringement procedure that King has presented so brilliantly now, the Commission framework, inserting this idea of a preliminary dialogue with offending infractor state, and finally this, which I consider to be the less interesting one, the Council dialogue, because it's very vague and undefined. But together, the four instruments may play a role. My criticism to them is the following. I think all of them are highly reactive instruments. What does it mean? That they only can be activated once there is an infringement, once there is a breach. And hence comes my proposal. I think what we need now is more of an ex-ante mechanism of scrutiny and control. An ex-ante means before any breach happens. And because of that, what I will propose is the creation of a kind of annual assessment of compliance with the rule of law in all and every member state. I know that it's going to sound terrible that I'm proposing something for all and every member state. There is one reason I mentioned before. Hungary is not alone in scoring very high in certain measures, not in all of them, but in certain measures. But besides, I think it's very important, one argument that is a normative argument has been raised by Hungarian authorities, not only Hungarian authorities. If you look at the performance of regional organizations all across the world, it's a systematic argument raised once and again. And in some cases, in situations in which regional organizations behave against the law. I'm taking, for instance, the case of Mercosur in Paraguay, which probably you don't know, but Mercosur in Paraguay basically behave against the law. The argument is equality. And the argument says, you know, it seems that this kind of scrutiny mechanism, that this mechanism to verify compliance with the rule of law applies only with certain specific countries out of the sport. So the mechanism or the way to bypass this objection about inequality will be to have an instrument that applies across the board to all and every member state before ex ante anything happens. And this will take into account basically what are the new bills or new projects being enacted there. Basically, this is the kind of working method that the Venice Commission has got. The Venice Commission does not approve legislation. Basically, it adds on bills who are not yet enacted. And that gives a lot of leverage because you can react before anything has happened yet. Additionally, of course, I would propose that this assessment is constructed on the basis of comparative standards that are common to all and every member state. And this, again, a mechanism that is developed from the working of the Venice Commission. And finally, one third element that I should really put on the discussion is who should be the body carrying this assessment. Here, there are a lot of proposals from the Copenhagen Commission, even though the Copenhagen Commission is again thought as a kind of reactive instrument. So I am speaking about an ex-ante instrument. I don't have any particular preference, but I would suggest that we shouldn't really rule out the event of outsourcing this kind of exercise to third bodies, for instance, the Venice Commission. And I don't think that the arguments, criticism made against the Venice Commission are very solid. The main argument has been that the Venice Commission is a body of the Council of Europe in which there are countries which are not democratic. But if we follow this argument to the very end, we will deny legitimacy to other bodies, for instance, perhaps the European Court of Human Rights, because it's part of the same system. And taking to the absurd, we will say, of course, international law has got legitimacy because it's part of a system in which non-democratic states participate. So I'm not suggesting that we should really go in that direction, but I'm saying that we should really think carefully which mechanism is there for doing this exercise. Now, the argument, of course, the criticism that anyone can raise is why another instrument? And I think here I will come back to what I have labeled the Draghi doctrine. If you remember Mario Draghi in the crisis of the euro, the height of the crisis of the euro, Mario Draghi said, I will do whatever is needed to save the euro, to rescue the euro. And I will translate the same kind of expression or principle to the rule of law. And I think we need as much as needed to make sure that the rule of law is respected in the European Union. So we shouldn't be blind by the idea of having more procedures or more mechanisms. What is important is the result, the end result, respecting or trying to make sure that the rule of law is respected. Would that be enough? I have spoken about 5 mechanisms and I'm proposing even an ex-ante control. I don't think so. I don't think this would be enough. Simply and honestly, I don't think it's enough. Why? Because at the end of the day, the essential factor to make any of these instruments, or the 4 of them, the 5 of them, in conjunction to work, is political will. And political will is not only depending, and I share parts, by and large, I share Kim's criticism of the Commission, that's also perhaps Dimitri's point. It's not only political will in the Commission. We know about the difficulties of the Commission to implement procedures such as the excessive deficit procedure or the sexy imbalance procedure. So there are always this kind of resistance. But we have also similar problems of political will within the Council. And I would say, with all my due respect to the members who are present here, that we will have similar difficulties in terms of political will from the European Parliament, if the European Parliament wants to take a role. Today we heard that apparently there are some new interesting developments, but still this has to be improved, and the European Parliament so far has not activated the mechanism that is available in the treaties. Now, my response is perhaps very pessimistic. I don't think we have enough mechanism, because at the end what is there is political will. And I think that one thing which is absolutely essential, even though it's again not highly popular and very unlikely to happen, is that we need treaty revision. And we need treaty revision specifically for doing, in my opinion, 2 things. First, we need to introduce stronger sanctions, which are properly detailed. And that line, I really agree with Kim. We need stronger sanction mechanism. Second one, I think the European Union should evolve in the direction of certain other regional organizations, introducing an even stronger last resort. And the last resort would be expelling a member from the European Union. This is a real nuclear option, no suspending voting rights. The real nuclear option is expelling one member from the European Union. And why this is a nuclear option? Because it creates the kind of situation we have in the Cold War, the terrorist mechanism. The existence of this mechanism makes it unthinkable that you can use it, but makes more credible that you can use other mechanisms. And this is the point. It's not to spare one member state, it's to make more credible that other mechanisms can be activated because the cost will be low. Basically, I'm translating here, paradoxically, the doctrine of nuclear deterrence. And finally, I think one point that is important to also include in an eventual treaty revision is a stronger reinforced role for the court. And I think it makes a lot of sense, something that has been perhaps a little bit neglected, but I think is very important if we are talking about rule of law, which is introducing the rule of law in the mechanism for scrutinizing the rule of law. And that means basically giving a more important important role to the European Court of Justice in scrutinizing and redressing what has been the activation of each of these procedures. Let us remember that when the Austria case happened, there was a strong complaint by the Austrian government, and I think there is a big consensus that there was not a specific case in the Austrian case, and there was a strong complaint by the Austrian government that there was not any kind of mechanism for redress for them to be heard at the European Union level. And I think if we are serious about respecting the rule of law, the mechanism we design should respect also the rule of law. Now, to conclude, and that will be my last point. Contrary to dominant interpretations, I think that the European Union should do whatever it takes to make the rule of law is respected, and that, in my opinion, means including an instrument that can police ex ante potential situations in which breaches of rule of law can happen. But lately, any mechanism will depend very much on political will of not only member states, but also on the factor political elite and citizens alike. And that takes me to one of the reflections I wanted to raise to the very end of this my intervention, which is what are the specific societal conditions that make that in certain countries tolerance of illiberal populist politics persist. We have focused so much here, we are focusing very much in this discussion about violate the government institutions, but perhaps we should also ask what are the specific societal and institutional conditions that allow that this kind of configurations can work and produce certain results. And perhaps here the European Union has got some kind of responsibility. In the morning there was some reflection about the fact that in certain countries, for instance certain European countries, the promise of European Union integration was a strong leverage for introducing certain kind of mechanism. And I think one of the problems we have now that in certain countries the European Union is not such a appealing idea, and that gives a larger room of maneuver for domestic elites to implement specific illiberal policy. I think we should reflect deeply about that. So thank you very much, and I hope I didn't go over my